on though. Let's move on to our third speaker, Dr. Karmen Lutman, whose presentation will be on the measure of liability and unjustified enrichment and change of position defense, a comparative study. Dr. Lutman, the floor is yours.
I think you need to turn on your microphone, please. Mute yourself, unmute yourself.
Thank you. Good morning and good afternoon to everyone. It's my pleasure to take part in this conference, especially in such a prominent, in a panel with such prominent co-speakers, and it's also my pleasure to contribute to the legal discussion dedicated to the law of unjust enrichment. On this occasion, I would also like to thank the organizing committee for accepting my paper. In my presentation, I will talk about, I will focus on the measure of restitutionary liability in the law of unjust enrichment. So it is a rather technical issue, but as Professor Martinek already mentioned, unjust enrichment and especially restitutionary remedy following by unjust enrichment is very, very technical in its nature. So I will focus on the content and the scope of restitutionary claim. It is generally acknowledged that the defendant should return to the creditor what he or she has had unjustly received on his expense. So the measure of restitutionary liability is unjustly achieved benefit, also called enrichment. So most legal systems agree on this point. However, a closer look on this issue showed that no uniform approach to the meaning of enrichment as a measure of restitutionary liability has been adopted for all types of enrichment claims. So my presentation is divided into three parts. In the first part, I will examine the question whether the measure of restitutionary liability is the benefit received or remaining benefit. In this regard, I will examine the applicability and characteristics of the change of position defense in civil law jurisdictions, also known as disenrichment defense or rather disenrichment rule. In the second part, I will briefly analyze the question to what extent the restitutionary rules differ from one another depending on the type of enrichment claim. And in the third part, I will examine the role of good and bad faith when measuring the liability in unjust enrichment. So to start with the problem of measuring liability in unjust enrichment, more precisely the issue whether the measure of restitutionary liability is the benefit received or rather the benefit remaining in the defendant's hands at the time of litis pendentia, so at the time when the restitutionary claim is filed. For example, if someone received a car in a good faith that he was actually entitled to it, and it's subsequently turned out that there was no valid legal ground or there was an unjust factor to retain this car, the defendant is obliged to make restitution, so to return the car. However, if this car has been was destroyed in the meantime, and the defendant is no longer enriched for its value, and also, for instance, provided that he was not compensated by the insurance company, the question arises, is he obliged to make restitution of the value of the car received, or is he relieved from the obligation claiming that he is no longer enriched? So the question, the basic question is, who is about bearing the risk of subsequent changes to the benefit received. So is the claimant or the defendant who should bear the risk of disenrichment, or might this risk be somehow fairly allocated between both parties? So historically, there was no general rule limiting the defendant's liability to the actual enrichment at the time of litis tendentia. In Roman law, the recipient liable under convictia, so one type of enrichment claims, was actually obliged to return the benefit received or to restore its value, notwithstanding the fact if he might have ceased to be enriched. There were some exceptions to this rule, but they were interpreted very narrowly. However, the value of the remaining enrichment was a regular measure of restitutionary liability under another type of enrichment claim, so-called actio de in rem verso, which was limited to cases of so-called three-party enrichment claims in Rome. According to this claim, the recipient was entitled to make restitution of the benefit still remained in his hands at the time of litis tendentia. However, the scope of actio de in rem verso was subsequently broadened, and in the 18th century, it came to be used as a general enrichment claim. So medieval scholasticism and natural law doctrine were in favor of limiting the defendant's enrichment liability by taking into account subsequent disenrichment. And yet it was the Pentectistic of the 19th century that set disenrichment or the existing enrichment as a general measure of enrichment liability. So following this Pentectistic doctrine, a special provision on loss of enrichment was introduced in the German Civil Code under the name Wegfall der Bereicherung, and it provides that restitution is not owed to the extent the recipient is not longer enriched. So the similar provision can be found in the Swiss Code of Obligations, and change of position was also a similar rule or defense was also recognized in English law, as previously mentioned by Professor Gallagher in the case Lipkin-Gorman, and it is also this change of position defense known in American law. However, it must be stressed that this enrichment rule or change of position defense applies only to good faith recipients and is in general interpreted very, very restrictively. However, comparative analysis show that there is no consensus within the European legal systems on adopting a general principle of disenrichment. For instance, in French law does not provide any equivalent protection for defendants in cases of so-called répétition del indu. So it is one type of enrichment claims, also in Roman law known as condictio in debiti. So it is so-called performance-based enrichment claim. With this type of enrichment claims, no disenrichment defense is possible. So the defendant is obliged to make restitution of the benefit received, despite he might already be disenriched at the time of the claim is filed. So as we can see, the French law has still acknowledges similar system as already known in Roman law. So, but it might be important to also to mention that in France, the courts may reduce the scope of the claimant's recovery if the claimant acted with fault. This position in France is different with the case of other type of enrichment claims, and this is known as an enrichissement injustifié, and this is the general enrichment claim, where with this type of general enrichment claim, the measure of restitution is the relevant date for the measuring the restitution is the day when the restitutionary claim was filed. So this means that the defendant is obliged to return only the existing enrichment, even if he was in bad faith. So in this case, this enrichment defense is of no use because the measure of restitution is already the decisive time for measuring the restitution is already the time when the claim was filed, so the time of litis pendentia. In this case, the claimant bears the risk of defendant's disenrichment. So model rules of European private law, such as draft common frame of reference and principles of European law of unjustified enrichment, recommend implementing disenrichment defense as a general defense to national legislators. So by applying this recommendation, the measure of liability in unjust enrichment should in general be the benefit received, but the good faith recipient may reduce the scope of such restitutionary obligation by proving that he is disenriched wholly or in part, and the restitution in full would make him worse off. The Slovenian Code of Obligations does not contain an express general defense of change of position, but there is a special provision which allows a bona fide recipient of compensation to claim disenrichment if it subsequently turns out that the compensation was without valid legal basis and he is no longer enriched. So given the tendencies in the European private law, the Slovenian theory and also the case law have already recognized a general recognition, a general defense of change of position defense in Slovenian law for all types of enrichment claims, although it is not provided in the code. So moving on to the second part of my presentation, more precisely to the question, to what extent the diversity of enrichment claims affects the rules of restitution. So the difference between restitutionary rules arises not only between different legal orders, but also between different enrichment claims within the same legal order. As already mentioned today by Professor Martinek, the approach towards the law of unjustified enrichment is not as uniform as it might appear at first sight. So the reason lies in the historical development of enrichment claims. Different types of enrichment claims were namely developed separately from one another. Some of them are therefore closer to tort, some of them closer to contract or to property law, or even to negotiorum gestio. So the starting rule, which is more or less common to all legal orders, is that restitution should be made in kind, and if not possible, in money. However, different approaches may be recognized when it comes to monetary restitution. So evaluating the monetary value of the received benefit is acknowledged as one of most challenging issues of the law of restitution. So received enrichment, such as movables, immovables, services, which could not be returned in kind, are normally evaluating by referring to the objective criteria, for instance, market value. So the decisive factor is the market value of the received benefit. However, there are certain exceptions to this rule, which are linked normally to certain types of enrichment claims. For instance, the first example, I would like to mention so-called induced enrichment. In German law, also known as aufgedrängte Bereicherung. So in this case, the measure of liability is subjective value for the defendant. To give you an example, if someone paid for reparation of the fence, of the garden fence, and the workers mistakenly repaired also the fence of the neighbor might claim that he is not enriched for the costs of the service, since he intended to remove the fence or even to repair it by himself with lower costs. So in this case, the criterion for the evaluating this enrichment is actually this subjective value for the defendant. And similar position can also be found in English law. With regard to the enrichment claims followed by the investment into a foreign property, some further particularities may be observed. For instance, if someone made an investment into another's immovable in a belief that he would become its owner, which is quite often in Slovenian law, and later it didn't occur, so he didn't become an owner. The measure of enrichment claim is not the objective value of services or expenditures made for the property, but increase in the market value of the property. So in such cases, also the restitutionary liability is limited by a so-called double cap rule. This is a rule founded actually in French law, double plafond rule. And according to this rule, the defendant should make restitution of the increase in market value, which should not exceed the value of expenditures made in the property. So this is the position in many European legal orders, including Italian, French, and also Slovenian law. With regard to this type of claims, so the claims for improvement of another's assets, it has been pointed out in German law, for instance, that this type of enrichment claim has a different function in comparison to other types of enrichment claims. So while enrichment claims in general serve the function to exhaust the enrichment, the unjustly received benefit of the defendant, claims for improvement of another's assets aim rather to compensate the loss suffered by the claimant. So for this purpose, the restitutionary liability is limited by claimant's loss, which is, for instance, usually not the case with other types of enrichment claims. For this reason, it has been called also that such enrichment claims form so-called atypical enrichment liability, also in German law called unechte Bereicherungshaftung. Moving to French law. In French law, there are two different sets of restitutionary rules. So two different sets of restitutionary rules have been established with regard to previously mentioned two types of enrichment claims. So on the one side, conditio indebiti, and on the other hand, the general enrichment claim. So while the measure of restitution in conditio indebiti is usually objective value of the benefit received, and also, so for instance, market value of object received or service, measure of restitution in other instances of unjust enrichment is rather a compensation which is limited on both sides. So on one side with the amount of enrichment in the hands of the defendant, and on the other side with the loss suffered by the claimant. So as we can see, the concept of measuring liability in these two types of enrichment claims is considerably different. And the challenging issue in the law of unjustified enrichment, which will be addressed today, is also the role of loss when measuring liability in unjust enrichment. So while in some legal orders, such as German and Swiss law, the role of loss as a prerequisite for enrichment claim was significantly undermined, including English law, where the loss shouldn't be taken into consideration when assessing the scope of restitutionary claim. The law still plays an important role as a condition and also a measure of restitutionary liability in French law, where general enrichment claim is rather loss-based. So, and lastly, I would like to briefly focus on the role of good or bad faith with regard to measure of restitutionary recovery in unjust enrichment. So it is acknowledged in most legal orders that the scope of restitutionary recovery depends greatly on the defendant's good or bad faith. So bad faith recipients and the recipients against whom the claim in unjust enrichment had been filed are subject to strict liability, which is close to liability in tort. So in contrast to good faith recipient, a bad faith recipient cannot rely on change of position defense and is therefore obliged to make restitution of the received benefit, although he might not be enriched for its value anymore. Moreover, the recipient of a sum of money who was in bad faith should also pay default interest. So also the scope of recovery of expenditures made in the received object also depends on the good or bad faith recipient. So the definition of bad faith, which varies among different legal orders, is therefore decisive for measuring liability in unjust enrichment, and therefore should be defined carefully, either in the code or, of course, carved out by case law. So some concluding remarks. As to the first part of my presentation, we can see that the measure of liability in unjust enrichment is usually the benefit received. While this benefit received can be reduced if the good faith recipient invokes a change of position defense. So this defense might be limited, as we can see in the tendencies in the European private law. We can see that this defense might be restricted in cases of unwinding mutual contracts, where this synalagmatic approach should be taken into consideration, and therefore it's not appropriate that someone invokes change of position defense while the other party is obliged to refer what he or she had received under this contract. So a change of position defense might be restricted in cases of unwinding failed contract. But in general, as I mentioned, this combination of received benefit, restitution of received benefit with the possibility to invoke a change of position defense is recognized in many legal systems, in many European legal systems, such as German, Swiss, English law, and also, for instance, in American law. Furthermore, it is supported by the draft common frame of reference, as previously mentioned. However, it should be noted that the change of position defense should be defined rather strictly, since no benefit in any form whatsoever should be left in the defendant's hands. In French law, however, measure of liability is either benefit received without possibility to raise change of position defense, or benefit remained, as I mentioned, with a general claim of unjust enrichment. As to the second part of my presentation, I can conclude that despite seemingly uniform approach to the law of unjustified enrichment, rules of restitution are not that uniform as it might appear. So the reason for this most likely lies in the historical development of different types of enrichment claims. Some of them are closer to contract law, other to tort, negociarum gestia, or property law. So while most of them are enrichment orientated, others seem to focus rather on the loss. So this might also be the reason to further insist on further refinement of enrichment claims in the future. And lastly, since good or bad faith play a significant role when defining measure of restitutionary recovery, it is important to carve out the exact features of the notion of bad faith and strict liability. So this concludes my presentation, and I would like to thank you for your attention.
Thank you very much, Dr. Lutman, for that very comprehensive analysis of the doctrine.